It's 3:15. We'll get started when we get everybody back in the house. And as we are getting ready to roll, I think we're going to move to the Citizens for a Healthy Community. Is that right, Ms. Hearings Manager Amaro or Ms. Larson?
That is correct. That is the next party on the list.
Good afternoon, commissioners. Can you hear me?
We can.
Okay, wonderful. And looks like we've got Chris there. So before we get started, as a matter of time allocation, we would like to allocate any unused time to the Wildlife and Biological Resources Coalition.
Okay.
Okay, wonderful. Well, good afternoon again, commissioners. Natasha Leger, Executive Director, Citizens for a Healthy Community. As this is the last leg of the Marathon Mission Change Rulemaking, I want to first start out by thanking staff and the Commission for all the work you've put into making the rules better. More importantly, I want to thank all of you for hearing and listening to all the parties and the public throughout this process. While we may not agree with all the outcomes, it is clear that you all struggled with fundamental principles of equity, balancing interests and goals, development versus protection, regulated community versus the public, and avoidance versus mitigation. I think I heard the term the precautionary principle used more times in the 1200 series than any other series, and I see that as a positive step. The package of rules you have advanced in the 1200 series and throughout the mission change rulemakings are significantly better, more protective of public health, safety, welfare, the environment, and wildlife. But we must all be honest, the rules do not completely fulfill the mandate of SB 181. As a recap, we want to thank you for listening to us and including geohazards and seismic monitoring for injection wells into the permitting process, addressing the importance of notice to water rights holders, and expanding public participation in local public hearings as just some examples. You heard us, you heard the voice of the North Fork Valley, and you worked to address our concerns. However, we recognize that these are all incremental steps. In our view, 181 called for clear certainty to the public on areas that should be off limits to development. That is avoided. The rules as they currently stand narrow avoidance measures to setbacks, alternative location analysis, prohibition of venting and flaring, and high priority habitats. While these are all important tools, gaps remain without a clear definition of adverse impacts and the means to avoid them. In the absence of a definition of adverse impacts, significant gaps in the rules include adverse impacts from geological hazards and induced seismicity from production wells, adverse impacts from greenhouse gas emissions, as well as adverse impacts to over 40 excluded species from high priority habitats. Those are just some examples. While staff has referred to the mitigation hierarchy of 181 as avoid, minimize, and mitigate, the rules bend more towards mitigation. For example, in the requirement in the 300 series for a geohazard plan, operators are required to describe proposed mitigation measures. To comply with 181, we asked that that be amended to include avoidance, but it wasn't. In the 1200 series, staff discussed the use of avoidance when presented with no mitigation options. The rules therefore provide for avoidance when mitigation is not possible, but that is not what the statute called for. The statute called for mitigation when avoidance is not possible. Those are two very different standards. We appreciate staff's explanation for the difference between the statutory and regulatory definition of minimized adverse impacts in the statement of basis and purpose. We respectfully disagree, and at this point, we'll agree to disagree. I do want to take this opportunity to say that as we are in the midst of a climate crisis and health crisis, it pained me to see that the Our Children's Trust petition was ignored during the mission change rulemaking. We owe a debt of gratitude to those kids who originally petitioned the COGCC in 2013 and subsequently brought lawsuit against the COGCC, the outcome of which resulted in 181 today and this mission change rulemaking. Those kids did a great service to the state of Colorado then and now, and look forward to them to doing more if we don't get these rules right. I know getting these rules right are important to you and to all stakeholders, but the spectrum of getting the rules right may differ depending on your perspective and your interpretation of the statute. We think the statute is clear, and getting the rules right means clear certainty to the public and the operators on avoiding adverse impacts and areas that should simply be off limits. We are pleased to see some commissioners committed to hard setbacks and carve out for high priority habitats, but there should also be a carve out for areas that are currently untouched by oil and gas development if we are to protect our life support systems as we transition to clean and renewable energy. We urge you to establish a biological resources working group of stakeholders to report back with recommendations by December 1, 2021. If we don't get the rules right today, we look forward to working with you to ensure we get them right sooner rather than later. Thank you again. Onward and upward, and this ends our testimony.
Thank you for that testimony. Do commissioners have questions? Thank you. I don't see questions. We thank you for your participation, and thank you for your presentation this afternoon.
Thank you.
Crestone Peak Resources.
Just waiting for David Stewart to join.
It looks like he's joining now.
Good afternoon. Can you hear me?
We can.
All right. Thank you. Good afternoon, commissioners. I'm David Stewart, Vice President of EHS and Regulatory for Crestone Peak. As this is the last time I'm speaking to you for the mission change rulemaking, I want to again express Crestone's appreciation for the hard work of staff and the commission in drafting, considering strong wildlife regulations that ensure the protection of Colorado's wildlife resources. I understand that there are three main issues that you would like operator feedback on. First, whether an exception or waiver process should be implemented for Rule 1202C, or if a variance is required, what variance criteria apply. Second, the aquatic high priority habitat buffers. And third, the compensatory mitigation fee. As to the adequate buffers, Crestone supports API Colorado and requests that the Commission acknowledge the unique and site-specific nature of these areas when considering an appropriate buffer. As to the remaining 1202C habitat buffers, I reiterate the importance of early consultation with CPW and strongly believe that a CPW waiver process for all 1202C habitats will result in no net adverse impacts to wildlife resources and will result in the avoidance, minimization, and mitigation of any adverse wildlife impacts to wildlife. If a waiver is not adopted, I agree with my industry colleagues that the variance criteria must be tailored to the relevant question of wildlife protection. And I agree that Rule 502C criteria number 1 and criteria number 3 are not relevant and should be eliminated from any Rule 1202C variance decision. Regarding your deliberation on compensatory mitigation, Crestone considered staff and CPW's original proposal for a $13,854 flat fee, which Crestone understands to be based on the average surface disturbance of pads in Colorado. Crestone always considers the most protective surface locations that minimize surface disturbance in all of its operations. Crestone is concerned about the late disclosure of the remaining 4 proposals for compensatory mitigation outlined in the staff's presentation yesterday, and urges the Commission to let this process play out before adopting any substantially different fee for compensatory mitigation. Evaluating any different proposal for a compensatory mitigation fee will require time to gather wildlife data through the 900 series reporting requirements and to evaluate which projects have been funded by any compensatory mitigation received. Further, as noted by Commissioner Gonzalez and Director Murphy, compensatory mitigation is tailored to a narrow issue and must be necessary and reasonable under the Act. Crestone urges the Commission to follow the recommendation of CPW and staff and implement option number 1 for compensatory mitigation. If the fee needs to be reevaluated in future rulemakings, all stakeholders can weigh in at that time based on the data collected. This concludes my remarks, and I'm happy to take any questions. Thank you.
Are there questions? Thank you, Mr. Stewart. Thank you both for your participation. It has been very helpful to our process, and we appreciate your involvement.
Thank you, Commissioner Robbins.
We will now turn to Audubon Society.
Good afternoon. Nita Culver with National Audubon Society. And once again, thank you for all the work that's going on. I'm not going to make any race or endurance sport references, but it's been a lot of work and we really appreciate it. I did want to start briefly just to circle back on the migration corridor issue. And I want to start with that because I don't want to just add more lawyering in and don't expect we're going to go back over this, but did want to note that this idea that Mr. Randall set out about regarding the most important significant areas of these migration corridors is something we support. These areas are important to both biological resources and other wildlife resources as well. And we do hope that the mapping and rulemaking discussion can be resolved in a way that will allow for acknowledgement in the rule. We think that will provide the most protection and also give CPW the best support for ensuring protection of these areas down the road. So I wanted to start with migratory bird protections. Beyond that, we really appreciate the addition of Rule 1202A4B and C, which expand opportunities to require an operator to fence and net or install other CPW approved exclusion devices on existing pits and to ensure maintenance. That's extremely helpful for avoiding harm to migratory birds. We just would reiterate, and I direct you to my comments on this and our red lines, that some clarification is still needed in the language of 1202.A8 regarding how an operator gets to decide that it won't comply with timing restrictions or requirements for exclusion measures. Turning briefly one more time to the greater sage-grouse and the Gunnison sage-grouse, we very much appreciate the protection for the Gunnison sage-grouse being now consistent with the greater sage-grouse in terms of a 1 mile buffer in Rule 1202C. And I'm sure they appreciate it as well in their dwindling numbers in the southwest part of our state. I did want to clarify the ongoing confusion we seem to be having over the current BLM plans and what is in the plans governing the greater sage-grouse. We've heard a lot of discussion of these provisions, especially in the 2019 plans, and in rewatching some of the testimony, it just seemed worth one more clarification. First of all, at this point, the 2019 plans are not in effect. They have been enjoined since October 2019. So BLM is enforcing the 2015 plans, and they'll be doing so until a judge in Idaho changes his mind. But most importantly, both the 2015 and 2019 plans do include 2 mile buffers around Lex. In the 2015 plans, the first mile is fully closed to leasing, while the second mile is no surface occupancy. In the 2019 plan, the no surface occupancy stipulation extends for 2 miles from the Lex in both priority habitat and general habitat management areas, but is subject to more opportunities for waiver exception and modification than in the 2015 plans. And I'm not arguing that the COGCC needs to be bound by exactly what the BLM is doing. I just want the discussion to be based in kind of the reality of what is on the ground and to acknowledge that in Colorado, our federal plans do include a 2 mile buffer for surface disturbance around Lex. So certainly what COGCC is doing in Rule 1202C can be supported, as can additional protections as we've proposed. On the compensatory mitigation and the mitigation fee, we really appreciate the range of ideas and the ongoing discussion. it does seem more workable to have a set fee related to a pad than acre by acre. But overall, I think we just support COGCC and CPW looking into the underlying assumptions for the fees and coming up with the best rationale for such a fee that we can all see and continue to track. Did want to address the riparian setbacks. We appreciate the 500-foot setbacks that are being used and would reiterate the value of this distance to protect a wider range of species, as well as the spill prevention measures from Rule 411 that are also being discussed. In our presentation, University of Colorado, Professor Joseph Ryan presented spill data in an analysis of 130 spills in 4 Western states with unconventional drilling over the years 2005 to 2015. He showed that the median distance from spills to water was 490 meters, and average distance was 750 meters. Only a little over 10% of the spills were occurring within the 300-foot setback. So there are a significant amount of spills occurring farther out. While that's good for that smaller buffer, I think it just highlights that there are risks in that broader buffer that need to be addressed. And Professor Ryan also showed a summary of spills for the DJ Basin in Eastern Colorado that focused on impacts coming from the spills. And it showed that from 2007 to 2014, there were more than 1,700 spills impacting surface water and groundwater. So the potential for harm to water resources, aquatic habitat, and the broader riverscape is real, and we encourage you to continue to take it seriously. Like many others here, we do support the idea of a general riparian setback and further discussions around that, as was mentioned in the testimony from the Western and rural local governments previously. And finally, if we are continuing to set up processes to talk about riparian areas and biological resources, we do support those and would be happy to participate that so that those are not put off for another decade. And appreciate your willingness to continue to support those activities. And that's really all I have today, so thanks so much.
Thank you, Ms. Culver. We appreciate your participation with us. Are there questions for this witness? Commissioner Nanjapa.
Thank you, Ms. Culver. Appreciate that presentation. And just a couple of quick clarifying questions. One was related to, just again, to just be really clear about the sage grouse rules with the BLM. So is it the first mile is NSO, so no surface occupancy, no, and wasn't there also a lease restriction there? And then the second mile was the buffer, but as I understand it, there is still the opportunity for waiver or variance. Is that correct?
Ms. Culver.
So in the 2015 plans we're under now, the first mile is fully closed to leasing. The second mile is a no surface occupancy, and there are slightly different standards for waiver in priority habitat and general habitat, but there are opportunities for waiver exception modification.
Okay, thank you very much. And then the other clarification was your sound was just kind of getting a little soft at the end of a couple of your sentences. And so in particular, you were talking about the spill distances, and I wasn't sure if you said 490 meters to 700 meters or feet.
Meters.
Meters, okay, thank you.
I think that my dog's trying to break in and bark at you all are drowning me out, so sorry about that.
Other questions? All right, great. Thank you again for participating with us, Ms. Culver. It has been very helpful.
Thanks.
I believe we now move to La Plata County. San Miguel.
Good afternoon, Commissioners. Maki Iatridis for San Miguel County and La Plata County. First, we'd like to thank you very much for adopting the 1 mile buffer for the Gunnison sage grouse. And as with many other comments, we'd like to thank you and the COGCC staff for the professionalism, the hard work, and the service to the state of Colorado through this lengthy rulemaking. We really appreciate it. And we look forward to seeing how these new rules work out and working with you in the future to improve them as needed. Thank you very much.
Thank you. We appreciate that. Are there questions? Great. Thank you again for participating with us, Mr. Iatridis, on behalf of your clients. It has been very helpful.
Thank you.
We now turn to Kendra Morgan.
Good afternoon. Let me just get my notes up. Let's share my screen. Okay, can you see a slide deck?
Yes.
Thank you. Good afternoon, commissioners. My name is Ana Gutierrez with Hogan Lovells, and I'm here on behalf of Kendra Morgan CO2 Company. So here's the scenario we are trying to avoid. BLM and CPW consult, and for good measure, let's throw Fish and Wildlife Service in the mix. These three agencies have analyzed the proposed locations based on an OGDP and the ALA, CPW data and surveys, the applicable federal RMP, and of course the commission's rules. With their expertise in federal judgment, professional judgment, they collectively determined that the commission's NSO within a half mile of an active nest of the ferruginous hawk should be modified to 0.4 miles and an NSO with timing limitations. Because in their experience, this area of, let's say, the BLM Tres Rios field office supports the species and timing limitations have proven effective. There may be additional consequences that the next location could impact elk migration corridor, or the site can't be moved out of the half-mile buffer because a logging road is adjacent, and BLM really wants the operator to use that road and not create a new one with new disturbance. So with this decision, we do have direct conflict with 1202C. There's no waiver process because we don't have one on the rules right now, but these folks write down some notes that they would support a variance. We go to the OGDP variance following the expenditure of significant resources. And we may not want to call it this, but that is an adversarial process. An operator is required to make her case, and then the commission may have questions about the variance. This is expected because this is a specialized area, and technically it's an application for variance. And because the variance is supported by federal consultation and influenced by federal planning, those questions really should go to BLM. But the federal agency is not present. They're the federal government. They can't be compelled to attend that hearing. So they can't respond to the questions. They can't react to suggested provisions, and they can't articulate potential implications that you or I might not be able to think about. So then what do we do? Do we delay this year-long process for resolution on federal engagement? Do we proceed without fully informed responses? I would submit that either outcome is unreasonable and can be avoided through an upfront waiver process. So let's say, for purposes of discussion, that at the end of the hearing, the commission denies the variance and the application, and concurrently, the permit is federally approved. This outcome raises federal preemption and takings questions, and unfortunately would likely result in a lawsuit. We don't want to get there, and we think a strong waiver process can help us avoid this result. We heard a lot of discussion on Monday, and frankly even today, about how the variance and the waiver get us to the same result. We figured you all get this to the same result, so what's the big deal? But based on staff's presentation yesterday, they clarified that these processes are very different, both in process and substance. And I think that this is further supported by the fact that the commission is considering a different waiver or variance process in these aquatic buffers. In my mind, there is a distinction with an important difference. So as staff says, a waiver is an exercise of CPW's discretion and expertise. It's CPW's direct delivery to the commission on their opinion. This will be received differently by the commission than a variance application. Just as some commissioners have suggested in this rulemaking that recommendations from CPW have been more heavily weighted, and in most cases more than other stakeholders. The waiver as a part of an OGD packet will also likely be processed by an ALJ or hearings officer. And this often occurs administratively or on a hearing consent agenda for the commission. So it's rare for something to come off the consent agenda. In contrast, a variance, the application, is an adversarial process to contest application of the commission rules. And it includes showings that we've had conversations about that may not be relevant. So when we're talking about operations on federal lands and when a variance involves federal input, it seems we would want to work cooperatively with the federal agencies through a waiver process to give industry, to give the federal agency some certainty to how that consultation input would be treated. And let's keep in mind that this will also inform the federal government's review, which I think for all of us, we'd like to happen concurrently. But as drafted, I'm not sure concurrent permitting would win the day. But the big takeaway here is that there is a complementary program in place by the federal government and one that is consistently cited by the commission and CPW in support of these rules, and we should respect that. Staff indicated in its closing that 309 EC3 addresses the waiver question. We respectfully disagree. We agree with the rule, we agree with the SFAP language, but we disagree. This section exempts an operator from consultation if CPW agrees in writing that there's no habitat, or let's say there's commercial property already. From a federal perspective, even that decision that there's no habitat would require federal consultation. But the key point is that even if this does waive consultation, that's not our goal. We want consultation to happen and we would like for it to be documented and respected. I've made this point before, so I will respect your time and be brief, but it is worth reiterating that the current 300 series do not address how the federal agency will interact with CPW. That's why 309E was pulled out into this rulemaking. And I think it's worth noting that neither does the MOU, because CPW is not a party to the MOU. CPW and the commission are different agencies with different expertise and different decision-making points in this process. Staff's stated position is that there are no federal waivers in other series, so why should 1200 series be different? Two responses. First, we think a waiver process in those examples, which were reclamation and secondary containment, would have been appropriate, and we testified to that. With reclamation in particular, we have regularly experienced conflict, and we would have, we think a waiver process would have made sense there. Second, even if those scenarios don't have waiver processes, species is different. Species analyses require specialist expertise. That's why COGCC brings CPW to the table, and BLM brings biologists to the table. So this is apples and oranges comparison. We heard from CPW that they consult with BLM on site-specific projects and federal planning all the time. It's what they do, and they do it well. And this is Kendra Morgan CO2's on-the-ground experience. It's unclear to us why there is pushback in creating a transparent process for CPW's interaction with its federal partners. In particular, when BLM has expressed in writing the importance of the rules to recognize the role of the federal government. I do also just want to clarify for the record what the BLM mission is. It is on their main website, and it is to quote, sustain the health, diversity, and productivity of public lands for the use and enjoyment of present and future generations. I also think it's important to recognize that BLM's mitigation hierarchy, it aligns with yours. It aligns with 181, which is to avoid, minimize, and they have a few more words in there, but same concepts: rectify, reduce, eliminate, and compensate. Kendra Morgan CO2 does not ask that the commission consult with BLM and document that consultation because BLM's process is easy. It's not easy. We are simply aiming to create a process to avoid conflict. With those points made, we continue to advocate that in those circumstances where it's necessary, a waiver process is more appropriate than when the federal government is involved. The language you see on the screen is new, same concept with revisions, and I'd like to walk through those. First, we relocated this to 309 E5D3 because other waivers are addressed at 5C. Second, we added that CPW's decision would be based on its analysis of potential unavoidable adverse impacts. This models staff's language at 5C and makes clear that CPW retains its ability to make an expert judgment, notwithstanding what the federal government says. Third, we included language that the waiver will contain reasonable COAs and mitigation measures to stick with 181. Avoid, minimize, mitigate, in that order. This language comes directly from the last provision of Rule 502 variance process. With these more robust sideboards, we hope this gives the Commission confidence that this is not intended to be a provision that creates full deference to the federal agency, nor does it undermine CPW's judgment. We hope we can come together on this language to achieve the same goal of protecting species while working together with our federal partners. If, however, this Commission decides to not take the path we've proposed, and you stick with a variance process, we propose this language on the screen at least. And I want to be clear, this is a secondary option only, because this is our last conversation to have with you. We feel compelled to give you language for consideration in that case. That concludes my remarks, and I welcome questions.
Thank you for your presentation. I see a couple of hands have raised. I think I saw Commissioner Gonzalez first, and then Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Ms. Gutierrez, for your presentation. I've got a, the whole federal preemption thing. I think we've heard some, we've heard some different things on that across the board, and I understand your take that that basically if the federal permit comes out, that authority trumps COGCCs, or so is how I understand from your testimony, and that it could lead to a lawsuit. And I don't want to go down that road and that hypothetical, but I'm curious if the litigation wasn't part of that conversation, what would that look like if COGCC denied an application that had been, kind of fully vetted and approved by BLM? What would that look like for the operator if they wanted to come into compliance with the COGCC permit and their BLM permit?
Thank you. Oh, if I might.
Yes, please.
Thank you for the question, Commissioner Gonzalez. So, base level, I hope we're all on the same page that the goal is not to get there, right? The goal is to have a process so we can avoid that. So we have all these conversations up front. I think the analysis is a little bit different if we're talking about a COA condition versus a full permit denial, right? So the Commission may just deny the variance, or they may fully deny the permit. If we're talking about the COA or the stipulation, whatever it might be, I think CPW and BLM would ideally work it out. If they can't work it out, I would expect that those conversations, even during the permitting process, would be elevated both within COGCC and BLM, because we would want to reach resolution on that before getting all the way to the end, right? We want some level of certainty. But if we get to the end and there's a full permit denial and the federal agency has approved the permit, it's just a little bit more challenging. And even at the COA stage, I think it ultimately comes down to conflict and can we figure out how to have a meeting of the minds? And we're just trying to have that conversation earlier in the process with a little bit more certainty in the process. I think any COA that, let's say, take my hypothetical. I understand if you take a Venn diagram, you have the NSO, the no surface occupancy, and then you have BLM's timing limitations. Somebody might say, if you draw a Venn diagram, technically you can comply with both, right? If you comply with COGCCs, you would be also within BLM's. The problem that creates, though, is you're essentially denying BLM the ability to access those minerals and permit that facility there, and there may not be another alternative. So, I guess at the end of the day, I think it would come down to a question of conflict and how those agencies can work through that. And we're just trying to create a process for that conversation.
Commissioner Najapa.
Thank you. I appreciate the explanation just there to Commissioner Gonzalez's question. I'm also just, I think I'm maybe a little bit stuck on the waiving any of the operating or mitigation requirements, although I think, and I just want to make sure that I think you're also saying, or you're saying it's not a full-on waiver, but it could contain additional conditions of approval or mitigation measures. So it's not a carte blanche waiver that you're asking for. It's CPW taking a look, analyzing, and then also potentially adding additional conditions. Is that correct?
Ms. Gutierrez.
Thank you, Commissioner Nanjap, but yes, that is correct. Any operator should expect that if they have any movement off of a COGCC rule, that would be accompanied by substantial COAs, right? This is not just an attempt to avoid compliance with COGCC rules. In this case, where we're talking about the federal government, we're truly just trying to accommodate how these rules can work together. And I think one point that's important to make is there will be circumstances when CPW, BLM, they come to the table and they decide, you know what, BLM, you have to make movement off of your rules, which would require BLM to insert an exception into their programs, into their permits. All we're asking for is that as partners with those federal agencies, that you have a similar opportunity in your rules to accommodate BLM's program if that was necessary.
Other commissioners with questions? Commissioner McGowan.
Thank you, Mr. Chair. I have two questions. Thanks for your testimony this afternoon and trying to clarify kind of what this conflict is in your mind. One of the reasons that I think that I vocalized my reasoning behind the variance for the aquatic species was that the trade-off, sorry for the waiver, the trade-off of getting closer was guaranteed best management practices and more protection if you were then closer. And I'm not sure how that principle gets addressed when we work with BLM, for example. And if there is this kind of conflict between our rules, our ability to say, yes, we would consider a waiver off-ramp when we're working with the federal government. How do we assure that the trade-off then, and the other commissioners may not agree with me, this is just my philosophy perhaps, that the trade-off for exceptions to our rules is equal or better protection?
Thank you, Commissioner McGowan, for the question. So I think there's a few pieces in there, but for starters, my goal to address that specific issue, because like I said, we expect that if there is a waiver from a 1202C rule, that would be accompanied by measures to avoid, measures to minimize, measures to mitigate. So we maintain this consistency with 181, that it is no net adverse impacts, right? No additional adverse impacts. But I think one piece that I would also emphasize is that I understand 181 reads different than a multiple use mandate. That's true, right? But when BLM is implementing their NEPA process, they manage those programs and those lands and those environmental and wildlife species under the same mitigation hierarchy as you would on the commission. So I don't think your goals are as far off as folks may suggest. And the piece though that's important for this sort of coordination is that BLM does have a multiple use mandate. So we can't just carte blanche put our rules on top of theirs and ignore what they have to say. And I wouldn't think that would be the expectation. So we're just trying to create the opportunity for when there is conflict, these folks can work through that early and work through that through a variance process.
Thank you, Mr. Chair.
Sorry, I'm muted. Go ahead.
Thank you. I'm curious to know if you heard the conversation with industry earlier and their suggestion that if we cannot or choose not to go the waiver process and we keep the variance process, did you hear the proposal about eliminating, sorry, I'm gonna have to go back and look at my notes, 1 and 3 from the variance process for just for the wildlife?
Thank you, Commissioner McGowan, for the question. Yes, I did hear that. I think this scenario is different because, again, we're involved, or this scenario, every circumstance that I'm talking about involves the federal government. And where I see significant difference between a waiver and an application for variance is the application for variance is an adversarial hearing before the commission, and it's essentially deciding on a decision BLM made that we can talk to, we can speak to, but I can never present myself as counsel for BLM, right? That would be inappropriate. Whereas if you go through the waiver process, the way I understand this process is that after you have triggered, you submit your OGDP, you trigger formal consultation with CPW, they do an exceptionally in-depth analysis based on that OGDP, the ALA, conversations with BLM, and whomever else they think they need to have those conversations with. They, in their expert judgment, determine that a waiver is appropriate. That waiver then gets folded into the OGDP package, goes to technical committee, goes then to the director. The director then has a recommendation. The way I understand the rules is that any OGDP that is submitted for application to the hearing is quote automatically assigned to an ALJ or hearing officer unless the commission pulls that back by formal order. And then once that ALJ and hearing officer hears the matter, it makes its decision in an order that goes before the commission on consent agenda typically. And as we all know, consent agendas are generally approved in wholesale. Something can be picked out for discussion, but that's far less common. So it's an entirely different process, an entirely different set of circumstances, and you don't bring me, the attorney, to the table to, make the case and see what the commission has to say about it.
Thank you. I think I'm definitely appreciative of if you went through a rigorous process and both parties say this is the best option recommendation, that it might seem frustrating to know that in one instance a group gets to go waiver process and potentially not have to go through yet another hearing with folks and regurgitate things when agreement has been made versus having to go through a whole nother hearing and process. I appreciate all the points that you're putting on the table.
And if I might, Commissioner McGowan, just to supplement that, and this is to respond to a question that I think Commissioner Messner has posed several times, which at the end of the day, COGCC makes the decision on the permit, right? We all agree that that's the case. When you go through the waiver process, as I described it, or through the variance process, there's a risk. There is a risk at the end of the day that COGCC says, nope, I don't like it. We're denying this application. That likelihood, that risk is much smaller if you go through the waiver process than if you went through the variance process, in my mind. And I think when BLM is involved, that risk calculus should matter because it's not just the operator's concern, it's not just COGCC's concerns, but we're trying to permit these operations ideally concurrently. And if they don't have any real confidence in what happens at the very end, I don't know that we're going to have that, right? We might just have BLM permitting ahead of time, and then frankly, that's a much more difficult predicament to be in.
Commissioner Najapa.
Thank you, Mr. Chair. And could you, Ms. Gutierrez, could you put up the slide that you had with, I think I captured your primary proposal, but I just wanted to take another look at that secondary proposal.
Sorry, I was on mute. Thank you, Commissioner Najapa. I will do that only if I can also reiterate that it is truly a secondary proposal. We really want the commission to consider this in full.
Duly noted.
Okay. Take a quick. Okay. Let's see here. Okay, I see. So, and really the primary difference here is, again, that your primary proposal is a waiver process, and this is in the event of a variance where there would be inclusion of what was discussed with the federal agency and their stipulations or conditions of approval. Yeah, I mean, so, and understanding, all the points you made, I think you made some important points that, for us to consider with respect to the process and the complications and the steps that are required. Yeah, I'm just trying to understand. So the primary difference there is that the primary proposal is a waiver. And that, in your mind, provides more certainty, even though the decision comes at the end of the OGDP process. It provides more certainty than this, even with this language added. Is that fair?
Thank you, Commissioner Nanjapa. Yes, that is accurate. I think this language, well, if you go the variance process, I would appreciate adoption of it. It's pretty soft, right? It's a consideration, and ultimately you are considering at the end of the day. But when you get to something that is a waiver and that it is robust, it's attached with COAs, it has been analyzed, and CPW will document its analysis of the unavoidable adverse impacts, which will include analysis of minimizing adverse impacts, mitigating adverse impacts, and anything else we need to look at, right? This is a significant and robust process. This is not to suggest that a waiver should be easy, but this is intended to have really some teeth to it, so that if you go down this route, CPW has an opportunity to tell you, the commission, with a lot of support and justification, why this waiver is appropriate, and then that gets folded into the OGDP, and is a very different process than, me appealing to the commission for a variance.
If I may, Mr. Chair, just a final follow-up here. So just, and as has been pointed out, and I think you even said it yourself, that what we're talking about here is the opportunity for CPW to weigh in and potentially waive in their consultation, these pieces that as you have up here in the slide, with the so I'm just trying to in so doing, that's part of the consultation that occurs early in the process. And so if they would tell you that they are not going to waive or that they are going to deny, then you could scrap your process or start something new and go elsewhere. Is that ultimately the nut of it?
Thank you, Commissioner Nanjapa, for the question. Yes, I ultimately think there is a lot more certainty. If we have a robust waiver process like this, we would even know what those COAs are. We would know whether the operator can be comfortable with that. And if CPW ultimately says, no, I'm not comfortable with shifting to the BLM NSO with timing limitation, then we have to have a conversation with BLM. We have to figure out, all right, well, they don't want this location here because they wanted us to use this logging road. What then can they do? What other location are we not thinking about? What other impacts to BLM's land use management planning are we not thinking about? And we have them in a fluid state, right? We're all having a conversation and can modify things a bit in a way that where you're in a variance hearing, you can't do that.
Commissioner Gonzalez.
Thank you, Mr. Chair. And do I understand it correctly that that CPW is already in a consultation with BLM? They're participating in the on-sites, and so when site selection occurs, CPW is already going to have had a seat at the table and have agreed to that site with BLM, in which case, if they give us a waiver and there are COAs that are developed later on, it's not like you're going back and starting from scratch, because that's what CPW is going to come to the table with us at COGCC in that consultation process.
Thank you, Commissioner Gonzalez, for the question. So typically, yes. So historically, CPW has sometimes attended the on-site, and when that happens, I think Mike Hannigan shared with us during his testimony, that's been very productive. because we hear CPW's concern that says, hey, there's an eagle nest over there. We don't want this site here. Can we shift it this way? And BLM says, well, we have concerns because this is elk migration corridor. Let's look over here. That's what the onsite is at. They're physically at the site having that fluid conversation. So yes, we do have some, so let me pause there. They weren't always at the onsite. And I don't think that we can require that they always be at the onsite. That is our preference. But I can tell you that with these new rules, which are far more rigorous, there will be a lot more coordination. I think there's going to be a lot more effort between CPW, COGCC, and BLM to have those conversations early. And we made revisions collectively, this group, in the 300 series to reflect that. So we have those conversations along the way. When we start with those, we can modify our application to reflect those conversations. So then when we get into that trigger for the formal consultation, it's even more fluid, right? And then we can dive in a little deeper and dig a little bit more and have more focus on what that waiver would look like. And then further and further, you can refine it. So it gets all the way through this process in a really thoughtful, critical, with thoughtful and critical analysis.
Thank you for the dialogue, Ms. Gutierrez. It has been very helpful, I think, to commissioners. And thank you for your continued work on behalf of your client in the rulemaking. It's been helpful.
Thank you.
I'm not seeing further questions, so I believe we will move to our next panel, which is TEP.
Good afternoon, commissioners. Thank you
Good
again for your
afternoon.
time. And perhaps for the last time, Michael Jewell, on behalf of Terra Energy Partners, TEP Rocky Mountain LLC, we want to use our time in accordance with the suggestion made by Chair Robbins to have a more collaborative approach. And we regret the time limitations that we all naturally have to contend. It makes it feel like some of these requests are in shorthand, and in essence they are, but we know that some of these things will kind of hook your attention, or in collaboration with others will get more traction. So thank you again for the way you think through these things. And speaking of shorthand, we pretty much certify almost everything Kendra Morgan just suggested, but we'll leave it at that ditto for now to save time. But 3 quick items: one of efficiency, one of federal security, and then one about surface owner management. Chair Robbins stated that recycled comments fail to strike the goal of a collaborative sharpening of rules. So we want to focus on the flow chart that has been referenced several times today regarding the variance process. Now, Tara does agree in that flow chart, the variance process does cut down some of the inefficiencies that we were fearful of in our pre-hearing statement in our discussion yesterday. However, we think it can be sharpened a little further. And we're suggesting that, again, when you have this objective waypoint of a federal lease stipulation, so going a little further than what Kendra Morgan was saying, but you have this actual stipulation regarding several species where, as Commissioner Gallen was suggesting, where it's at least or more protective than your current NSO rules, then we're recommending that a sign-off be allowed as an off-ramp when CPW looks at those stipulations, when we apply for our broader application and says, yes, these stipulations fulfill our understanding on the lands. We feel like that saves time for everyone. It maintains the expertise that BLM has put into these STIPs with NEPA, RMPs, and even the ESA. And it keeps all the players at the table, especially and including CPW. And the second point about competing missions between BLM and COGCC, Commissioner Messner was correct as far as perhaps it be a balancing act with BLM, but that's limited in the permitting realm. As we all know, BLM has far more jurisdiction in other agencies that constitute this federal corpus. And so there is lots of kind of hands cooking the stew, if you will, for endangered species, leasing, and flipping considerations for these STIPs even come before you. So we believe that this whole new mission is going to be corroborated with this inclusion of BLM and CPW at the table. Lastly, Tara knows that with all the discussion surrounding surface ownership and stewardship, the BLM acts not only in its capacity for itself regarding the surface, but also usually the National Forest Service and adjacent fee owners. And we remind that only to suggest that when you're dealing with the peons, you're dealing with most of the West Slope, you're already dealing with a heightened sense of scrutiny with wildlife because of BLM's vast presence where at least my client is operating. Therefore, all we're asking in 1202C is for the hard work to be put into place for easier recognition, not only for operators, but also for the alleviation of additional work for staffs across all the agencies we've been discussing. So thank you very much for your time, the opportunity to be collaborative, and for your careful consideration that's gone back from, gosh, has it been August now? So thank you very much. Happy Thanksgiving.
Thank you, Mr. Jewell. Are there questions? Commissioner McGowan?
My apologies. There was some fast talking on your part and I had some distractions. That's the danger of working from home.
The 5 minutes are ticking too, so.
So can you go back to the very beginning of what you were talking about and the request to sharpen our variance process and what that looks like? I'm not sure I quite understood.
Well, Tara wants to be clear in that we recognize the allowance of the variance process to have some deviation from the proposed NSO standards. We don't want to be so obtuse that we're suggesting to you that that doesn't work at all. It can, but as suggested by several parties, it could be clunky and takes a lot more time, and it is adversarial. We don't want it to be adversarial when the protections, at least for my client, are evident as objective waypoints within the wildlife stipulations in their actual lease. So they're already having to follow something that, when followed, is more protective for that species than just the rote NSO standard that's in 1202C right now. But we're taking it a step further by suggesting when you have this objective piece of paper that represents interagency work led by the BLM, that have CPW look at it, and if they sign off on it as part of the application, it's an actual off-ramp for that rule. Again, because it is at least or more protective for those species than what would be suggested by 1202C.
Commissioner McGowan?
Thank you, Mr. Chair. So in this case, it sounds to me like, is it concurrent consultation that's happening, or did you go to the BLM first, for example, and then you showed what BLM signed off on to CPW and then they signed off on it and then that's your off ramp?
That's a great question. It's presupposed that perhaps when the lease was granted, let's say 2015, that science was done at that point in time. That's why it's so important, not that we say, Commissioner McGowan, look, we have a lease stipulation. We recognize that there's a gap there. That's why CPW is so important at that point to say, does this jive with what you believe is the boots on the ground at the moment? And with those two agencies signing off concurrently, we believe we are recognizing the authority of every agency involved.
Other questions? All right, Mr. Jewell, looks like you're off the hook. Thank you very much. Appreciate your presentation and your being with us. We'll now turn to Small Operator Society.
Thank you, Commissioner Robbins. I see Mr. Ratliff and Ms. Brodsky on, and I think Mr. Ratliff will kick us off for us. Thank you very much.
Yes, thank you. Good afternoon, Commissioners. My name is Dale Ratliff on behalf of CPX Peons Holdings and the Small Operator Society. Also with me today is Gwen Brodsky. We appreciate the opportunity to provide closing statements on the Commission's proposed 1200 series rules. Gwen is going to speak first to the proposed buffers and rule alternatives for the aquatic layers, and I will speak to the application of the variance procedures to request under Rule 1202C. Gwen?
Yeah, thank you, Dale. Commissioners, thank you for another opportunity to participate in this rulemaking. I'm Gwen Brodsky, and I'm representing CPX Peons Holdings and the Small Operators Society, of which CPX is a member. With regard to aquatic habitats, The commission asked for feedback on 3 options. SOS supports option C, which provides for waivers in some instances. And we ask that you also give new thought to the distinction that's being made between native aquatics and cutthroat trout. This is a challenging part of the rulemaking and warrants some deliberation. So far, the outsized distinction doesn't seem entirely supported by the record material or statements from staff. We previously showed in our testimony that 5 of the 7 final RMPs from the BLM and Forest Service in Colorado show buffers for cutthroat trout in the 300-foot range, which suggests that the cutthroat buffer isn't entirely distinguishable from what it would be for native aquatics. And like native aquatic species and sport fish, cutthroat trout have variability in CPW mapped habitat, some of which does not show as just the high elevation headwaters that has been discussed here. We also noted that in our testimony and discussed with commissioners that we haven't seen indication that the cutthroat buffer distance isn't playing its role to help preserve and protect cutthroat trout habitat. We understand that commissioners and others express that there's a new mission under SB 181, but commissioners also express that this doesn't mean all existing rules are no longer adequate. In fact, we heard CPW say yesterday that they're comfortable with buffer distances between 300 and 500 feet for aquatic species, and they didn't make a distinction for cutthroat trout. And lastly, commissioners also pointed out that numerous other important species warranting protective measures fall under the umbrella of native aquatics, but we're reserving outsized consideration only for cutthroat. And I think CPW helped to put this reliance on buffer numbers into some perspective yesterday when they said that hard and fast buffers often aren't a component of a species recovery plan because they can't be relied on for the species recovery. And this is all just to say that while we all support the cutthroat trout protections, we believe we've raised some points to at least reconsider before emphasizing this hard distinction between native aquatics and cutthroat trout. And I'm going to pass this back to Dale to discuss some remaining points about variances.
Thanks, Gwen. As Gwen just explained, SOS supports the adoption of the waiver provision as proposed in option C and requests that it be applied to all 3 of the aquatic layers. We've previously explained in detail, so I won't go into it here, but why we believe that a pre-application consultation and waiver process would prove effective, efficient, and sufficiently protective of these resources. But we also understand that the Commission may still choose to adopt the variance procedures for cutthroat trout for all 3 of the aquatic layers and or for the remainder of 1202C. So SOS requests that the Commission adopt a workable variance process that reflects the unique circumstances presented by 1202C variance requests. To that end, we have the following comments and suggested revisions. First, SOS supports the proposal to tailor the Rule 502C variance criteria to better fit the unique circumstances presented by 1202C variance requests. The Commission should adopt the proposal to remove elements 1, unable to comply, and 3, undue hardship from the 502C variance criteria when applied to requests under Rule 1202C. Many variance requests from Rule 1202C buffers will simply not fit neatly into these 502C elements. For example, for an existing location now encompassed by one of the expanded or new buffers, it may be possible for the operator to comply with the buffer by developing a new separate location outside, but it may not be the best outcome. Depending on the site conditions, the resource values and their condition, and any relevant conditions of approval, the operator, CPW, and the Commission may all agree that it's preferable for the operator to utilize the existing location. But strict application of the 502C criteria could prevent that from happening. There are many of these existing operations already in the field. For existing and potentially stranded locations, there needs to be clear due process for the adequate demonstration of these unusual and appropriate circumstances. The variance criteria for Rule 1202C should reflect this fact, and removing elements 1 and 3 from Rule 502C when applied to Rule 1202C requests would help effectuate this goal. Second, we request that the commission memorialize a mechanism for operators to receive CPW input in advance of submitting a complete variance application. You know, we understand now that for certain 1202C habitat areas, or even potentially for all, the commission may choose to prefer the variance procedures for evaluating requests for exceptions from the 1202C high priority habitat buffers. But the rationale supporting early CPW input and involvement in the process still holds true for a variance process, and staff and CPW appear to support and acknowledge this. Staff clarified yesterday that the variance process begins with a pre-application consultation. Staff indicated that this process was optional, but strongly suggested that it would be in an operator's best interest to engage in this process before submitting a variance. And we agree. We appreciate the description by staff and CPW of how they envision the pre-application consultation process to operate. The rules, however, do not currently provide any mechanism to allow for this type of early input and coordination. Accordingly, SOS requests that the commission include the following express language in Rule 502B. Let me share my screen. You should all see that here. This addition would codify what we understand to be SAFID and CPW's intent for the 502 variance process as applied to requests under Rule 1202C. And this addition should be acceptable to staff and the commissioners based on the discussion we heard yesterday, which referred to CPW pre-application consultation, CPW providing its recommendation, and CPW's written concurrence, all as part of the variance process. All we are doing here is simply trying to memorialize that intent and make it absolutely clear that operators have the ability to engage in this process just as recommended by CPW and staff. And then finally, as a practical matter, we want to note that a variance request for 1202C can be a no-go decision, a go or no-go decision for many operators, and we anticipate that many operators, even with the pre-application consultation process we've discussed, may wish to file a variance request prior to spending the time and resources necessary to prepare and submit the full OGDP application. For this reason, we believe it's vital that the commission provide this mechanism for pre-application consultation, but also that they acknowledge, contrary to some of the statements we heard in deliberation, that it may be both reasonable and appropriate for operators to submit a variance process following a variance application, following this pre-application consultation process in advance of submitting the complete OGDP application. Last, the commission requested party input on the proposed compensatory mitigation framework and amounts. As the commission can likely appreciate, it's difficult to respond in detail to the new proposals and methodologies we heard for the first time yesterday. For that reason, SOS requested the commission retain the mitigation fee amounts and framework from the proposed rule. In particular, we think it is important that the fee amounts be based on the cost estimates that acknowledge that not all habitat loss is long-term. The mitigation fee provision applies to all ground disturbance, which includes activities that will result in only short-term habitat loss, and the cost estimates should account for this. These cost estimates should also form the basis of the rule, as they form the basis of the rule proposal that has been in existence since May. Thank you, and we'll take questions.
Thank you for the presentation. Do commissioners have questions? Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you both for your testimony today. I have a question for Mr. Ratliff regarding what you were just discussing on the variance and the pre-application consultation in particular. We do have in 309E5E, you know, a rule that says that CPW may make written recommendations on whether a variance request should be granted. I'm just curious what your request, how your request differs from what is there currently.
Okay, and so I don't have my 300 right in front of me, and I should have, but I think I have it pretty well memorized on this point, and also on the 500. And I guess the way we read it was that while consultation is required for all high priority habitat areas, and consultation is required for variance requests. There is no absolute mechanism in the 300s for when consultation can be triggered until you submit your variance application. So the provision that you're discussing, the way I read the rules, would apply when that formal consultation period is triggered, following the submission of the variance application. And so you have that 60-day period for consultation. And we still think, obviously, that 60-day formal period for consultation will occur. We're talking about the part in staff's presentation that said pre-application consultation in the flow diagram. And Mr. Staff and Mr. Holt spoke to the fact that they thought that that would be a beneficial process for most operators to engage in. They anticipated that to be the process. And I believe you heard Mr. Holtz give an example where he said, you know, some operators may come with less information and it'll be less beneficial. And those that come with more information, you know, will have a better starting point on which to give input to them. And the operator may get a good idea, you know, of whether we're going to support this at all or under what conditions. And we just don't see a mechanism in the rules that actually provides the operator the ability to request that engagement, except informally, and think that there is value memorializing it here, basically memorializing this process and the right to seek that input.
Other questions? Okay, thank you very much for the panel. We appreciate your
Thank you.
being with us and your participation. It's been helpful.
Thank you.
We will now turn to Western Resource Advocates.
Good afternoon. Thank you, commissioners. I'm Jorah Walker on behalf of Western Resource Advocates. As Chair Robbins suggested, we're proposing some solutions to some outstanding issues. WRA and others have advocated for more upfront and more certain protection of biological resources, including special status plants, and for wildlife outside of high priority habitat that's done in a way that facilitates public participation and informed decision making and takes advantage of existing highly credible sources of data. We propose that a recent rule change to 309E2B proposed by staff at the behest of the Commission just the other day be augmented slightly to encompass Colorado state threatened and endangered species, and you can see the staff changes in red, and our proposal is just that blue underline section. We support the proposal that a stakeholder or working group be established to figure out how to ensure COGCC rules do indeed function to protect and avoid and minimize adverse impacts to biological resources, including special status plants. But we also ask that the scope of this effort be expanded to include all special status species outside of high priority habitat. We believe there's enough parallels between protecting special status plants and animals to warrant consideration of both these issues in a single process. WRA is also, and others have also advocated for buffers for all Colorado waters of the state based not only on wildlife habitat values, but also to protect water supply, water quality, hydrologic function, recreation, and scenic beauty. We propose a stakeholder group to address buffers for Colorado waters. We note that in its testimony, Western rural and local governments suggested the idea of a stakeholder or working group to address buffers of general or statewide applicability to Colorado waters. In making this suggestion, the Western Government Group stated it was not opposed to general riparian setbacks and that the issue had indeed been put off since 2008. We hope that because there seems to be genuine interest in tackling this issue, that the Commission will endorse and facilitate such a working group. We also propose a slight change to the alternative location analysis rule, which we believe has been held open to address wildlife issues. Currently, ALA is triggered when a proposed location is in or immediately up gradient from wetland or riparian areas. But this provision is focused on water quality impacts and doesn't address situations where, doesn't address wildlife impacts because locations close to wetlands or riparian areas do not need to be up gradient to impact wildlife. Plus, this provision is vague and may steer locations close to wetlands and riparian areas as long as they are not immediately up gradient from those wetlands and riparian areas. To make things more clear and to protect wildlife habitat, we suggest proposed rule 304B2B VII. And we have an alternative to this in case this VII is considered to be the only subsection still open to change from the 300 series rules, which would accomplish the same thing. Finally, WRA supports a 500-foot buffer around all the aquatic waters, so that's the QRS waters, with variances that provide opportunity for public input and the chance to influence CPW before CPW has come to a conclusion. To require CPW or the Commission to show harm before additional protective measures can be taken forecloses proactive action to, for example, foster wildlife resilience in the face of climate change or development pressure. To consider more protective measures only when harms have been documented would be like waiting to reduce greenhouse gases until harms from climate change are documented. Adopting this wait until harms are documented approach would foreclose more effective and less expensive solutions and put species at risk from harm. Regarding variances, as this hearing has established, the public has expertise and a lot to add to decision making. Waivers aren't as simple as some stakeholders would suggest. The more facts there are behind a waiver, the more decision making would benefit from public input and the creation of the record. Thank you.
Thank you, Ms. Walker. Are there questions for Ms. Walker from commissioners? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Ms. Walker, for happy to see you again. Can you explain to me the public input piece, and are you only requesting public input for the aquatic species? Because that's the way it reads to me, but I'm...
Ms. Walker?
Oh, yeah, I can understand why you would think that. Because I raised it in the context of the 500-foot buffer. You're absolutely right. But no, I didn't intend it to be that way. And I apologize for that.
Okay. So you are advocating for public input to the CPW application process for all the 1,200 species?
I think what I'm trying to say is that we support the variance process as a way to deal with situations where an operator wants to locate inside a buffer, the 500-foot buffer, over these other processes, because we believe that the variance process creates the record and gives the public the most meaningful opportunity to influence decision making. So it's a little bit backwards from what you said, but yeah.
Okay, thank you.
Yeah.
Thanks.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Ms. Walker, for your testimony. I was curious if you heard the suggestion from the Wildlife Hunting and Anglers group about applying the 411 best management practices for waters, for any location that was within 1,000 feet of one of the aquatic habitats as identified in 1202C.
Yes. I did hear that, and I'm fully supportive.
Other questions from commissioners? Thank you, Ms. Walker.
Thank you so much.
Your participation with us, and we will move to the next panel, which is Noble, Oxy, and PDC.
Commissioners, are we ready?
We are.
Very well. Good afternoon. I'm Dave Neslin, appearing on behalf of Noble, Occidental, and PDC. I'll briefly respond to the questions you posed yesterday. First, regarding aquatic buffers. We support option 3, Commissioner McGowan's proposal, with the refinements suggested by the industry group. Option 3 resolves disagreements regarding distance and process in one package, and the industry group's refinements will further improve it. It properly differentiates between aquatic species in a manner supported by the record. It incorporates BMPs from Rule 411, which you previously approved for preventing and containing spills, and it incorporates both waivers and variances. The refinements suggested by the industry group will improve this approach for the reasons they've stated. And you can make further adjustments through later rulemaking if it's warranted. Second, regarding the question of waiver versus variance, we continue to believe that a waiver process will help to focus and expedite the resolution of wildlife issues and should be incorporated into Rule 1202C as suggested by the industry group. Mr. Durandlo presented a very thoughtful summary of the variance process, but that process hasn't yet been used, and it's questionable whether it will function as efficiently as he suggested. As Ms. Gutierrez explained a little while ago, the variance process is likely to be more legalistic, more adversarial, and it includes a couple of standards that fit poorly in this context. Third, regarding the question of compensatory mitigation, we support the proposal by the staff and CPW set forth in draft Rule 1203 because it's the best available option. Options 2 and 4 rely on conservation easement values that aren't comparable for this purpose. Specifically, they reflect appraisal values up to $1 million for conservation easements in Pitkin County. But the COGCC website indicates that only 2 oil and gas wells were drilled in Pitkin County during the last 30 years, and that oil and gas is not produced there. In addition, Pitkin County is a world-class tourist destination with ski resorts and other amenities that increase property and easement values such that they are not comparable to oil and gas producing areas. Because options 2 and 4 rely on easement values that are not comparable, they're not reliable. Options 3 and 4 assume that all habitat loss is long-term and don't account for short-term loss that's mitigated by interim reclamation. But interim reclamation is a legal requirement. Rule 1003 mandates that once drilling and completion end, an operator must commence interim reclamation within 3 months on cropland and 6 months on non-crop land. And it further requires that aside from the wellhead, tanks, and access road, the remainder of the disturbed area must be reclaimed as nearly as practicable to its original condition, including restoring and revegetating the land. The agency's enforcement guidance and penalty policy provide that a failure to comply with this requirement is a Class 2 violation, punishable by a penalty of up to $10,000 a day. Because options 3 and 4 ignore the interim reclamation requirement, they too are not reliable. Option 5 uses a per acre fee rather than a flat fee to encourage smaller locations. but a per acre fee won't change location size. The three companies base the size and configuration of their locations on various considerations, including most significantly safety, but also COGCC and local government setback and other requirements, the available land, surface owner dictates, and existing land uses, which are considerable in the DJ Basin given its history of agricultural development and increasing residential and commercial development. Assessing a per acre fee won't override or materially change those considerations. I want to briefly address the issue of migration pinch points and stopover areas. It would be premature to adopt NSO requirements for these areas at this time because, as Mr. Holst explained, CPW doesn't yet have definitions for them, nor has CPW mapped them. It would be inappropriate and I believe inconsistent with the Administrative Procedure Act to adopt NSO restrictions in the abstract for areas that haven't yet been defined or identified. This issue can and probably will be revisited when the maps are updated in 14 months, as Mr. Holst testified that pinch point maps should be available then. During the interim, CPW will receive all oil and gas development plans, can consult on them, and can recommend avoidance or other requirements to protect these areas as they are identified. Mr. Randall agreed that that should work. Finally, on behalf of the three companies, I want to again express our thanks to each of you commissioners and to Director Murphy and your managers and staff and the other agencies who've been involved for all of your work and professionalism throughout this rulemaking. I'd be happy to answer any questions.
Thank you, Mr. Neslin. Commissioners, are there questions? All right, getting off light today, Mr. Neslin. Thank you very much.
Thank you all very much.
I believe we are now turning to the Western and Rural Local Government Group. Is that right, Ms. Larson?
That is correct, Mr. Chair.
Mr. Chair, we also have Mr. Pedersen on the phone for Q&A. I just want to make sure that he is available if necessary via phone.
Okay, can we have him raise his hand so that Ms. Larson can get him as a phone panelist?
Via phone, is that a star numeral signal to raise one's hand, I believe?
Star, if he could try *6, if I'm not mistaken.
*6 to raise your hand, Eric, if you're listening, and he should be.
And also in the alternative, if we know the last
yeah, I was gonna say,
four digits.
What's the last two digits of his number?
Yeah.
Is he 52 or 90?
I've got
last 4 digits are 5190.
Okay. Very good.
Thank you, Mr. Nguyen. We've got him up now.
Excellent. Thank you for your patience. I think we're ready to go. Good afternoon, Chairman Robbins, Commissioners, Director Murphy. John Jacobs here again, Counsel for Garfield County and Party Representative for the 23-member Western and Rural Local Government Coalition. I want to join the prior party representatives in thanking each of you, Director Murphy, staff, and council for all your hard work. WRLG is responding today to staff's final revisions to the 1200 series rules through 2 witnesses with whom you are now quite familiar. Matt Lepore, President, Insight Energy Law, and Kirby Nguyen, Oil and Gas Liaison for Garfield County. And as I indicated earlier, present with us to answer the Commissioner's questions as necessary is a third witness, Eric Pedersen, Environment Team Lead and Career Professional Wildlife Biologist with SGM Inc. Now I'd like to turn it over to Matt Lepore.
Thank you, John. Good afternoon, commissioners. On WRLG's first day of testimony 3 months ago, 90 days ago, I read a quote from Global Energy Management Program's Statement of Energy Principles and Values. On our last day of testimony with you today, I would like to share another quote from that work. True sustainability requires a balance of economic, environmental, and social imperatives. This balance requires all stakeholders to reconsider cherished assumptions, tone down rhetoric, and compromise. In the modern energy world, nobody gets 100% of what they want. Everyone must recognize multiple imperatives to achieve a balance and be prepared to adapt as the balance point shifts over time. WRLG has tried to approach the commission, staff, and our fellow stakeholders with this philosophy. We appreciate that there are many valid competing interests at work with all forms of energy development. A pragmatic, radical middle approach is often the best way forward. The COGCC rulemaking community is a relatively small but rapidly growing one. We look forward to working with all of you again to address new and ongoing challenges. Commissioners, we thank you for your attention, your focus, and your open-mindedness. We appreciate your willingness to grapple with the nuances and to resist the temptation to reduce issues to simplistic binary choices. We appreciate having had a seat at the table and your consideration of issues of concern to WRLG. Director Murphy and your staff, you have been phenomenal from start to finish. You have moved mountains and somehow kept your poise and managed to remain calm and carry on. I also want to acknowledge and thank CPW for their hard work and professionalism in the 1200 series rulemaking. We found their testimony and responses to comments from Mr. Ackerman and Mr. Hulse and their staffs to be insightful, objective, and informative. Turning to the matters at hand. Yesterday, we heard an interest from at least 4 of the commissioners to explore flexibility in the buffer zones around the aquatic species within 1202C1, similar to the flexibility you built into the 604B setbacks for building units. In addition, we heard from Mr. Ackerman and Ms. Newman at CPW that a 300-foot buffer unequivocally is protective of the aquatic species in consideration here, and that buffer zone is supported by science. We did not hear that a 300-foot buffer would not be protective. WRLG's ask from the beginning has been that you revert to the 300-foot buffer zone for the native species and sport fish as staff had it in their original draft rules. In the alternative, we have said from the beginning, if the buffer remains at 500 feet, that a waiver be allowed on site-specific conditions. Based on yesterday's discussion about off-ramps in Rule 604 and best management practices in 411 A2B, WRLG offers the following proposed revision to Rule 309 E5D, which pertains to CPW consultation. So what I have tried to do with this language is find the simplest, cleanest way forward that I could think of to capture what essentially I believe Commissioner McGowan proposed and what I heard, again, support from for several other commissioners. The new language is in blue. The existing language is in black, and we've highlighted some portions of that. And this falls under the category of the result of the consultation with CPW that will happen under Rule 309E anytime an operator proposes something within high priority habitat, whether that is 1202C or 1202D habitat. So CPW may waive, hence a waiver, the application of, and the director may grant an exception. So it's a 2-step process. CPW waives, director grants, may grant, impliedly may not, may grant an exception. For 1202C1 RNS, we would say this: if the location, new or existing, is proposed to be less than 500 feet, but more than 300 feet, the operator would be required to put the 411A2B intermediate buffer zone best management practices on its application as conditions of approval. The commission may modify, because one of those conditions is for a daily inspection, we think that needs some consideration. Daily inspections in the terrain, in the wintertime, in the west slope, up valleys and ravines and canyons, it's tricky, so we would ask for some consideration on that. Other off-ramps for 1202C would remain in place. And then Kirby, if you'll go to the next slide. This is existing rule language in proposed 309. Again, same section, result of the consultation. Even with those 411B best management practice is in place, CPW may make written recommendations about how to protect wildlife resources, conditions of approval that are necessary and reasonable, or they may recommend in writing that the commission deny the development plan or the Form 2A. So I wanted this last slide just to show you that's already in the rules. You've asked a lot of questions about whether the commission could impose more BMPs or CPW could recommend more BMPs or deny a permit. All of those safeguards are there. And maybe Kirby, just go back to that prior slide 1 second. Again, to me, this is the simplest path forward. It's one amendment to your rules. The variance would still come in only if someone is asking to be closer than 300 feet. That's an extreme circumstance that we do not foresee happening very often. I want to take a little bit of an issue with something that Mr. Randall said. God bless Mr. Randall. He was my boss for many years. Have nothing but respect. But I disagree with him about the application of the variance at COGCC. In my experience, those 5 conditions for variances in 502 have always been very strictly construed. Variance should not be granted without those 5 things being met. That, I think, is how I applied it. That is how I've seen others apply it. I don't think it's a good outcome here for this 300 to 500 foot zone. And I should stop talking and give Kirby time to finish the rest. So thank you, and I will pass it to Kirby.
Thanks. Did you have something to say about Kendra Morgan? Did you include that?
Thanks, Kirby. I did not. We do support the Kendra Morgan's approach to consultation with federal land management agreements and their request for consideration when there is an approved federal land management site.
Okay. Thank you, commissioners. Good afternoon. It's been a long day, longer than I thought it was going to be, but I appreciate your attention to all these matters. Mr. Lepore has covered our positions and final requested red lines, so I really don't have a whole lot to add to that. We appreciate the continued openness of this commission to consider common sense waiver processes in certain situations, such as for the aquatic resources. Western and rural local governments, as you have heard previously, are at a disproportionately greater risk to great and permanent economic harm if the final rules do not contain reasonably flexible on a case-by-case basis options that ensure wildlife resources are protected, of course, but in a manner that avoids using an uninformed application of the so-called precautionary principle, but instead a process that allows the wildlife expertise of CPW to be engaged and leaning on the latest data and science along the way when they do that engagement and consultation, and so that they may provide recommendations to you and to the operators. We believe all stakeholders across Colorado will benefit from a process that encourages and involves rather than muzzles CPW, so they provide their recommendations by applying, again, that best information and science available for each permit consultation, which should include waivers as one of the tools in the overall toolbox. This need for flexibility and empowering CPW to do what they do best certainly applies, without question, we believe, to existing locations that an operator could re-enter versus tearing up virgin ground. Also for the aquatics habitats that we've been discussing that are too heterogeneous to manage with just one size fits tools. And also the federal permitting process, where a whole host of federal wildlife expertise has already come to bear on a location application in consult with CPW. And actually, we also believe the entirety of the 1202C, a case could be made to have some sort of flexibility therein on those habitats based on CPW expertise. Lastly, and maybe most importantly, on behalf of the 23 governments of the Western and Rural Local Government Coalition, I earnestly, truly want to thank the commission and staff for all their hard work on these rulemakings all these months. It's been a monumental lift for you and for all stakeholders. Once you have finished this rulemaking work in the next few days, the next big important lift will be the implementation. And we believe implementation will be a complex and challenging process as staff, the regulated community, and relevant local governments alike work to translate black and white rules that actually have quite a bit of gray area actually into functional processes for the 200 to 600 series and the 8, 9, and 1200 series rules. We absolutely look forward to continuing to work with you and staff and operators over the coming year to ensure these groundbreaking rules are implemented and so that they'll work as efficiently and work as intended. So with that, that's our testimony. We'd be happy to take the questions. Again, we have Mr. Pedersen on the line as well if you have any specific wildlife questions, such as grouse or other things.
Thank you, Mr. Nguyen. Thank you, Mr. Jacobs, and thank you, Mr. Lepore. I appreciated the closing statements from you and appreciate the words of the work that we've been doing. Do commissioners have questions? We've got yet another proposal on the table with regard to this. I know that I've been trying to take pictures of each one of these so that I've got copies of them for deliberation this evening and tomorrow. But to the world at large, if you do have red line language and you want us to consider it and don't want to, us to have to just do it on the fly, do get that to Ms. Larson.
We'll get those slides to you ASAP, Chairman.
Oh, Commissioner Nanjapa, sorry, I was looking at my notes.
No problem. Thank you, Mr. Chair, and thank you all again for your testimony and your comments. I just wanted to kind of note, because we've heard from various groups about the aquatic habitats, of course, and the differentiation in different scenarios. And I don't know if this would be appropriate for Mr. Pedersen, but just noting that you are not including Q in your recommended language, and I just wanted to make sure about that with cutthroat trout, but also whether there was any thought with respect to the separation of gold medal waters as a separate category.
I might
Mr. Nguyen?
first stab at that and then let Eric go. We're not opposed to what's been proposed by industry on the Q, the cutthroats. We don't think that the data suggests that it's an impossible lift to think that it might make sense for Q, R, and S to be handled somewhat similarly. As you saw in our red line, we're not calling that out. We absolutely feel like we need to see the R and S, and so there's a little difference there. But we don't oppose and think that it's impossible to think that the 300 foot is the absolute do not cross line for cutthroats as well. But we're not pushing that as something we're really going to fall on our sword for.
Commissioner Nanjapa?
Thank you, Mr. Nguyen. And again, if Mr. Pedersen would want to weigh in, would appreciate that as well. But also, what about the separation out of the gold medal waters? I don't think you addressed that question. Any desire for that or concern about that, or?
Mr. Nguyen?
It might be myself again, Kirby Nguyen. And if I get it wrong, my team members will straighten me out. I understand the gold medal to be part and parcel within the sport fish waters. So I'm not sure why they need to be specifically called out. When you're talking about these gold medal waters, you're talking about non-native rainbow trouts. I think in a lot of cases, there may be some other gold medals. We're not averse to taking a special close look at them. I don't think that the acreage for those, especially in oil and gas terrain, is significant enough that we're going to say try to push back. I didn't understand the science behind why they really do merit rising up above the other sport fish, but it's not a huge issue for us.
If I may, Eric Patterson, have you been following? Can you hear the dialogue, and can you weigh in on that gold medal waters issue that Kirby just spoke to?
Can you guys hear me?
Yes.
We can.
Speak up, though.
Yeah, I don't have anything else to add to that. I concur with Kirby's assessment of that.
Okay, just want to make sure.
Mr. Laporte, noting that your proposal, which we will look at, is for a waiver and an exception. If the majority of the commission were to go to a variance, or be in a variance position, are you still of the opinion that subsections 1 and 3 should not apply?
Yes, Mr. Chairman, I am. I think the conversation yesterday, Commissioner Gonzalez sort of teed that up nicely. I think, and again, this is where I do slightly disagree with Mr. Randall. I can see how you could shoehorn it in and say, well, you conferred and you consulted, and so it doesn't. You therefore have satisfied the requirement. What's the language? You made a good faith effort to comply. I feel like you're kind of bending over backwards to make an exception to the 502 that just doesn't need to be made. I mean, I think that's why there's a waiver process. In fact, the last part of 502C1 says, has made a good faith effort to comply, et cetera, including securing a waiver or an exception, if any. So there's kind of a hierarchy here where the variance is the last go-to. And there's a great opportunity to put a waiver in here that has some good sideboards on it. And then if, again, you want to get closer than 300 feet, then yeah, you need a variance and you need to explain why you can't be in the buffer zone or somewhere else. That's how I would look at it.
Thank you. Commissioner Gonzalez.
Thank you, Mr. Chair. And I had a question about, in your original testimony, you talked about a general waiver for 1202C and talked about the limitations of other species, non-aquatic species, and kind of the effective buffers therein. Are you satisfied with the kind of off-ramps provided through the 309 language that allows for CPW to make the determination that habitat doesn't exist and therefore would not be a part of 1202C and could move the permit forward in that way?
Mr.
Chairman. Thank you, Commissioner. So I guess the most honest answer is that as this process has gone on, WRLG has kind of narrowed its focus. So we're zoomed in tightest on the things that are most important to our group. We would still support a broader waiver for 1202C. And I do think some of the things that like we're talking about, like for 604B, where there were off-ramps of different kinds, the 309 that exist for the ephemeral streams, and if the habitat is not there, are important. Please don't take those away. But we would support, as some of the industry representatives stated, a broader 1202C waiver versus variance process.
Other questions for the panel? Great. Thank you very much. We have very much appreciated the perspective that the Western and Rural Local Government Coalition has brought to our proceedings. I think that it has allowed us to tailor certain of our rules so that we can be productive in how we're doing things across this great state. And so really appreciate your being a part of this, and thank you for your final presentation.
Thank you, Mr. Chairman.
Thank you. And those slides should be in Ms. Larson's mailbox by now.
Great.
They are.
Thank you.
Thank you, Mr. Nguyen.
Thanks.
Ms. Larson, I'm sorry, who do we have next?
We have WBRC next, and they have a total of 20 minutes and 27 seconds. There has been further consolidation of time.
Great. Let's bring them to the House.
All right.
Good evening or good afternoon. And while I'm sharing my screen, I'm going to try and bring it in at 15. That's the goal. Is the screen showing and can you hear me?
Yeah, Mr. Trappis, your screen is sharing. It's not in play mode if you wanted it to be. It's in kind of the mode that has the notes.
How about that?
Now you're there.
There we are. Okay, I'll start my time. And first thing I wanted to say was, like a lot of the other parties, Mr. Lepore just now, a genuine thank you and appreciation to staff, the commission, all of the party representatives and witnesses. And I don't think we've had a shout out yet to all the folks who showed up for public hearing a week or two ago Monday. And I'll just say I learned something every single day of this hearing. And some days I learned a whole lot. And I think we're all learning things that are gonna be beneficial to Colorado in the long run. I'll share perspectives on some of the issues we're focused on before I get into the 4 points that we want to summarize one more time. What this agency's mission today came up. Mr. Randall mentioned it on Monday, and I think it was responded to. And here's just my take for what it's worth, that COGCC retains multiple objectives, but the primary mission has flipped from accommodating and fostering development to protection of public health, safety, welfare, and the environment. The Act, as we know, directs COGCC to regulate oil and gas development when it's deemed protective of 181 values. Protecting the values is not waste. 181 deleted, once again, cost effectiveness and technical feasibility. And the Act authorizes COGCC to deny development that is not necessarily, that is not protective. And in our mind, that necessarily extends to denying levels of development that aren't protective of the environment. Just want to bring this one to the Commission's attention and the stakeholders. There's an op-ed over the weekend published by State Senate President Leroy Garcia. And I'll just read a few of the highlights relevant to this 1200. The bill prioritized our land, water, and wildlife, positioning Colorado as a national leader in oil and gas regulation, making us the first state in the West to rethink how we protect our environment for future generations. And he referred specifically to developing buffers that bravely defend wildlife and the ecosystems that support them. For quality of life reasons, including supporting communities and the rural towns they support, our Colorado way of life. So the waivers or variances, I want to come at it, not getting into the weeds of what some of these sections say, but kind of a big take. After listening to everybody on Monday last week through the rulemaking, a few of the things that stood out to me, where I hope we're in agreement on, is that our priority habitat is best protected through avoidance. We want to have the experts inform decisions, both at CPW as well as outside experts that may be retained by the operator, NGOs, citizen naturalists. Best available map and habitat databases supplemented and complemented by ground truthing. There's no substitute. We welcome the more science, the better. Not overdoing it, but we welcome that science-based discussion. And for me, the solution is obvious. We're not even talking about waivers versus variances or what the process is. If the operator does their homework first and gets that landscape level approval like Noble's 2019 CDP. And I summarized a few aspects of it there. And when it's just one agency negotiating with the operator, the old saying comes to mind: if you're not at the table, you're on the menu, right? And Commissioner Robbins was a land use attorney before he got here. Commissioner Messner was a county commissioner. My take is the way it works is that CDPHE under the Act consults on public health, CPW on wildlife, but the professional commission has the final say regardless of the staff recommendation, and the ultimate decision-making authority wants to hear from all the parties. This is a heavy industrial activity, and that's why it bears a high level of scrutiny. And I just found a quote when I Googled Noble's CDP, and it was former Commissioner Boygan saying, "I don't think we could imagine that something like that could be pulled off." The scope and the success of this infill drilling plan that Noble got approved. They've got 770 some wells they can drill now. They avoided all the high priority habitat, and they're plugging and abandoning a lot of wells, which is a net gain to everyone in the state. People, environment, operator safety, state fisc, across the board. Compensatory mitigation, briefly. Wildlife Biological Resources Coalition is that less of that is more. Once again, just emphasizing avoidance is the preferred approach, tied to the definition of minimizing adverse impacts in the Act. All habitats can't be replaced. I thought Ms. Culver put it well on Monday when she said these plants and these plant communities can't just pack up their bags and move to the next PJ habitat or across the river. They're rooted in place. Fiscal impact came up. Just want to hit on this briefly. And I don't know if the slide's showing real well, but the last big rulemaking was 2008. And I think the point is that regardless of how much oil and gas we've been producing in the last 50 years, our economy has done quite well and maybe grown too fast and attracted too many people for the health of our ecosystems and our environment. And these two graphs show crude oil increasing significantly after the 2008 rulemaking, and the same for natural gas. Major increases. And the reason that's relevant, I showed this one last Friday, but let's just pause again and think about losing 50 square miles of habitat per year in the state, which the study from 2007, 2016 said was 1/3 driven by energy development. So we do have an issue that we're trying to address, and we're trying to do it collaboratively. And I really respected Mr. Lepore's remarks in that respect. And, you know, once again, just to summarize, if we're trying to get serious about climate and we're looking at where 1361, our climate bill, interfaces with 181 and our oil and gas policies, we've got to take account of these major increases in both natural gas and oil production. Is it sustainable, whether the oil and gas is burned in state or not? The 2005 baseline year from 1261, natural gas production is up 40%. Crude oil production up, based on my figures, I think it's 800%. And just to review again, the Ghg Reduction Mandate, and this is a discussion that this commission isn't going to solve in this mission change rulemaking, but just to put it out there, because it's an important discussion we adults, we grown-ups need to have, and so do those kids that you heard about from Natasha, Ms. Leger earlier today. We're directed by the legislature, bill signed into law last year by the governor, 50% reductions by 2030, 90% by 2050, and that's based on all the best science. So to launch in on our 4-point plan, you've seen it, Biological Resources Working Group, we're really appreciative of the support we're hearing from the parties for this concept. CNHP, that's probably going to be part of the working group. Number 3, expanding HPH. We'll cover that in the most depth, and landscape level planning. We'll emphasize one more time what that means from our perspective. So let's convene that working group. Let's have the working group determine the scope collaboratively. Let's have it report back by the 1st of December next year. I think I heard support for a riverscape approach. Let's do the two of them. Look at our riparian wetlands ecosystems, and there'll be some overlap. We'll figure it out. And we look forward to constructively participating. I heard the affiliated local governments say they want a seat at the table, and I'm sure that the Western and rural local governments will as well. CNHP, probably gonna get farmed out to the working group, so I'll just pass on this one right now. For the high priority habitat designations, they really do matter. And we're saying, let's make them based on first, CPW's professional, expert, biologically supported recommendations that came both from staff and the massive stakeholder effort that went into Colorado's State Wildlife Action Plan. So it starts with the Tier 1 and Tier 2 species of greatest conservation need. We are saying that CPW's recs at a minimum should be what's reflected in the rules. We complement and fully support CPW for doing its job. And we're curious as to how that list appeared to get slashed by more than half in the final proposed rule. And this is going to be iterative. We're going to have more mapping exercises, and we hope to keep working with all the stakeholders to get the protections in the rule that are ultimately needed. It's worth remembering, we're talking about fossil fuel development. It's a triple whammy for habitat. You've got the direct disturbance and loss of habitat from pads and roads. Indirect cumulative impacts include the habitat fragmentation, invasive weed vectors, noxious weeds, more people disturbing wildlife from the new roads. And the medium and long-term climate change impacts, as we know, are driving wildfires, drought, compromised ecosystems, and watersheds that might not function for our communities anymore, in addition to people. We've made the case for both bald and golden eagles on half-mile buffers. I'll just, I'd like, you know, we're looking forward to a discussion with CPW on the case we're making. Was very much supported by Mr. Bovey's testimony in the first round of the rulemaking. Boulder County supported the half-mile buffers and explained why, in their mind, seasonal restrictions were inadequate. This shows Wyoming Fish and Game's 1/2 mile standards. Montana's got the same thing that they came to after an extremely comprehensive stakeholder process in 2010. So we're saying, let's be like Montana and Wyoming, and these half-mile buffers would be subject to requests to lessen them. I'm not supposed to be saying that, but they'd be like the other HPH protections, and Montana recognized it, Wyoming recognized it. We're saying let's start with 1/2 mile in the rules because they're justified. And golden eagles, the trends are declining slightly in the west and in the southern Rockies. And the final bullet there, from the SWAP, securing protection of large unfragmented habitats to alleviate habitat loss stemming from oil and gas development. It's right there on the SWAP, supporting the proposed buffers. Just to touch on the ferrets, once again, I think the black-footed ferret is one for me that when you've got the most endangered mammal in North America, we've got 7 reintroduction sites. It seems that species should be in the rule because the reintroduction efforts are such an important priority statewide and nationally and across the region. This is a list of most of the species that CPW had recommended that the last we looked are still missing from the proposed staff final rule. I'll just read the names of the species as I go through the slides. What we tried to do was put just a few bullets on each page talking about the status in the SWAP and some of the science and regulatory standards supporting protections. Mexican spotted owl, Swenson's hawk, eastern black rail, bird species in the eastern plains, The burrowing owl, you heard about from Boulder. Mountain plover, another grassland species that Ms. Hacko's Audubon's testimony talked about. Southwest willow flycatcher, another one that was within the scope of Joanne's testimony. Western yellow-billed cuckoo. Gunnison's prairie dog, which Ms. Golensky spoke to in her testimony on Monday. New Mexico meadow jumping mouse, Rebels meadow jumping mouse, swift fox, another grassland species which would get umbrella protection if we get aggressive and protective of our remaining grasslands ecosystems and restoration. Same thing for the white-tailed prairie dog. Mr. Clefane, who testified on Monday, gave us 2 plants, or one exemplary plant example, the Fremont's pestamon, which is endemic to the Piceance Basin and only occupies 3,400 acres. So that's one for the working group discussion, but it seems to me that protection and avoidance can be readily accomplished. Mr. Clefane also got me this slide for an example of a plant community. This one, the Western Great Plains Closed Depression Wetland and Playa, where energy development is recognized as a threat in the SWAT. Riverscapes, this slide is again from the SWAT, which says planning, implementation, and mitigation of oil and gas activities need to be something at a much larger scale. Once again, supporting the landscape scale planning that we're talking about. Few of the other species that Ms. Golensky compiled, they don't, and this is a summary. There's some questions about which of these aquatic and riparian wetland species, they're not mentioned in the rule. And the concern on that is if the operator retains an expert, they might not know that these species are grandfathered in with the aquatic designation. If a citizen or a local government open space biologist is just reading the rule, they don't know that these species, which CPW has said in good faith are covered. So that's a discussion I think that we want to flag and to have. Species not mentioned in the rule that may be covered in somebody's mind and in the agency thinks they are. So I put the definitions of the tier 1 and tier 2 species from the SWAP in here. The tier 2 are the highest priority, getting the most conservation emphasis. Once again, I can't say enough about the value of landscape level planning for Colorado's energy future, which, as you know, we see it as a just transition to a clean energy economy, where sometimes not drilling is going to be the best outcome for Colorado's climate as well as our environmental goals. So you heard about our 4 tweaks. Now I'll just go to the last slide, which I'm not, yeah, there we go. Problem statement, simple, serious, and solvable. Looks like it's gonna come in there, huh? Yeah, so we can do this. The simple part of our challenge here is that energy development is compromising habitat and wildlife at an unsustainable pace. It's a serious problem because if we keep doing what we're doing, we're not gonna meet the letter of the law or the goals in our conservation blueprint. And it's solvable because by designating all high priority habitats and ecosystems that warrant protection, we can get it done through landscape level planning and the best science, collaborative involving the operators, the staff, local governments, NGOs, and citizens. So thank you very much.
Thank you, Mr. Tropoulos, for the closing statement and for your participation with us. Commissioners may have questions. Are there questions for Mr. Tropoulos? Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Tropoulos. I'm not sure, it's not a question, but I think that staff explained why some of the species in the earlier draft weren't in successive drafts. And did you hear that conversation? I just want to make sure that you heard from staff why that happened.
Yeah,
I'll
confess.
I had kind of a similar question too, Mr. Tropoulos.
Yeah, I must have missed it. I caught most of the testimony, and that sounds like one that's very important that I should have heard and I didn't. So,
Yeah, some of the CPW officials testified as to how the list was winnowed down a bit and focused on a certain subset, but they also, if my recollection is correct, and correct me if I'm wrong, Commissioner McGowan, they testified that by having these identified ones, pretty much all the others still maintained protections. Did I get that right?
I think so. We might want to bring staff back on, and Commissioner Najapa might remember the conversation also. I also thought that some of this, to me, kind of linked into some of the T&E species are missing, but they are already protected through a different process. And then Commissioner Najapa had suggested in our latest draft, adding some language to make it clear that the threatened and endangered species would be addressed as well through the consultation process. So I'm wondering also if you have seen that language and if that helps address some of the species that you brought up.
yeah, I mean, I guess that would directly apply certainly to the black-footed ferret example, right? But, you know, I mean, from where I sit, I would repeat the observation I made that, and even as a practitioner, right, who's been practicing before this commission, mostly in rulemakings, but for better than 10 years, I start with the rules. I don't look back to the statement of basis and purpose. And to the extent, and, you know, I'll just kind of turn it around. The operators have been very clear that certain species that are listed, they're real concerned about what's listed and what's not because they perceive that as the ceiling. We want to see it as the floor. And, you know, that's just the state of play, but I think it's fair to the operators when they're trying to comply with the state rules, as well as the conservation advocates that are trying to protect these species. I apologize that I apparently missed an important discussion, and I'll try and catch up with Mr. Holtz and some of the other CPW. I'll contact council and try and get informed on that. But I think the species that deserve and warrant protection should be listed in the rule, would be my pitch.
Great, thank you. Other questions, Commissioner Nanjapa?
I'll keep it very brief, Mr. Chair. Thank you. And thank you, Mr. Chiropoulos. Yeah, just to respond on that, since, I mean, I had some of the same concerns, especially first looking at the rule about, you know, some of these tier 1 and tier 2 species that are not mentioned. But if you do go back and listen to the testimony from CPW, you know, I asked some clarifying questions related to that. And as Commissioner McGowan, you know, pointed out, with T&E species, especially, you know, federally T&E species, there's an automatic consultation that will occur, and CPW is looking out for tier 1 and tier 2 species when, you know, they're involved in every OGDP. So they are looking for those, you know, and I do believe that they are going to add additional conditions of approval when those species are in the mix. But I think, you know, you'll just have to listen for yourself from the testimony, and you know, we may have some additional deliberations on those things tomorrow, but there was some additional language that was added in the red line draft, as well as in staff's proposal or staff's commentary today, I think it was, or was it yesterday? It's all running together. But again, thank you for those concerns. I share them.
Yeah. Yep.
I was going to say, Mr. Chiropoulos, please go ahead.
Yeah, just my observation was, having practiced a lot of federal oil and gas, environmental and energy law, is that the Endangered Species Act is a scrap of paper. If you don't have citizens and expert NGOs like the ones who participated in this hearing and attorneys taking these cases before the agencies in comments and the courts when need be. And as we've recognized in past rulemakings, we've got a very strong pro-environment governor and executive branch in the state right now, but that may or may not always be the case. So once again, these rules and regulations do mean something, and they're gonna, loopholes and things that aren't mentioned can be exploited by future administrations. So, you know, just a plea to get it right.
Great. Thank you very much, Mr. Chiropoulos. We've appreciated your presentation and perspective that you've brought to the table, and I think it's been very helpful for us.
Thank you much.
Okay. Are we now at Climate Reality Project, Ms. Larson?
Sorry, I was having difficulties trying to unmute myself. We are. I'll bring Ms. Rose in, so just a moment.
Turn on my video and my sound. Can you all hear me?
We can.
Great. Let me start with a screen share and say I am riding dust again. I am always riding dust. Can you see my screen now?
We can.
You can? Okay, great. Let me play. As I said, we are the last presenter here today. Thank you for sticking with us. We will reserve our comments to that requested by Chair Robbins on buffers, waivers versus variances, and compensatory mitigation. For many years, I was an outfitter in the high country in the fall for bow hunting season in the Ghg range, and in the winter in rifle season in the Collegiate Peaks, which was also our summer range for backcountry guided fishing trips and camping on horseback. I've also been a backpacker for as long as I can remember. I got my first backpack at the age of 9. Regardless of where or when we went in our search for the perfect place to camp, the location always revolved around access to water and the location of fish and wildlife. So I'd like the Commission to keep that in mind, that water and wildlife go hand in hand. And I'm reminded of what I believe it was Greg Geronimo said about how once you've drilled the 5th well, all the wildlife is gone, so you can forget about them. Words to that effect, and I really hope that that situation never arises again as a result of this rulemaking. So in addition to the setbacks for endangered and threatened species that have already been established in the 1200 series, we ask for a hard setback of 300 feet from all sport fishing species and a very sparing use of variances with no waivers for 500-foot setbacks from cutthroat and gold medal fishing grounds. When people come in from out of state and from around the world, in the summertime, that is why they come, for gold medal fishing and cutthroat rainbow trout species. Temporary access to an energy source should never again be allowed to have a permanent impact on wildlife and aquatic species, particularly when weighed against the mandate of 181. So we believe the 502B variance process should not be utilized in place of 1202C, because wildlife has no voice. It did not participate in notice and standing. It was not a part of the application process. And it has no defense against earth movers and backhoes, and most importantly, against contamination. And you and the CPW have to act as their backstop. So we ask that you balance the cost of a few extra lengths of pipe and its associated materials against the loss of species or habitat that is invaluable to the web of life. This is particularly important with intermittent, ephemeral, and perennial streams, since they are the primary source of water for the truly wild within our state, those creatures that have not and will not accustom themselves to the presence of man. And these types of water sources have a tendency to move based on drought or flood, avalanche or mudslide, a fallen boulder, or even an animal carcass. So 300 feet minimum from those particular water sources is especially important, and it's the reason why we had to scout new base camps every single year in both the La Garita and the Collegiate Peaks. Water was never in the same place 2 years in a row. Again, people from all over the world come to experience these wild places, and hundreds of years from now, they ought to be able to do the same. So these wildlife and biological resources are terribly dependent on occasional, sometimes unreliable water sources. We ask that you please, please protect them. Finally, we propose that compensatory mitigation should be defined in the application process based on the location siting and the relative importance of the lost habitat or lost landscape. A permanently lost habitat or species is infinitely more valuable than a few acres within an already developed oil and gas field, and the mitigation fee should reflect that. Industry investments in comprehensive development plans should be appropriately weighed against the relatively minimal disturbance of a single well. Mitigation fees should reflect that, and they should be based around the information provided in the 300 series application. So we propose you define an amount based on the number of acres disturbed and its proximity to the other sources of encroachment, since that's the best determinant of impacts on our wildlife. And finally, I'd like to thank the commissioners. I'd like to thank all the staff. I'd like to thank every single party for the incredible amount of hard work and dedication and attention to detail that has been obvious throughout this rulemaking. When this cartoon was published, I really feel like the enemy was all of us who use natural resources and energy resources and trample on our environment. But we are in fact comprised of a group of people who care deeply about respecting Colorado's beauty and wildness. And we all see ourselves as stewards of this awesome land. It's been a pleasure working with all of you, and Climate Reality Denver Boulder chapter looks forward to working with you in cooperation and collaboration moving forward. Thank you again, all of you.
Thank you, Ms. Rose, for your closing and for participating with us. It has brought good perspective for us. So we appreciate you hanging with us here late on a Thursday evening. Do we have questions? Great. I'm not seeing questions, so we want to thank you again for your participation.
Thank you.
Okay, commissioners, I believe that we are through closing statements. Let me just touch base with Ms. Hearings Officer Larson. There was one other entity that had time, but they did not appear. Is that right?
That is correct. 350 Colorado, they were not able to participate, and they ceded their time to WBRC.
Oh, okay. All right. Then I think the next decision point for commissioners is, to what time tomorrow would you like to adjourn? We can start at 9. I would throw out on the table, we could also start at, say, 10 or something like that, to give ourselves another hour in the morning to collect our thoughts, which would give us an extra hour with our families tonight. Because I don't think we need all day to get through what's before us, and we could even start at, say, 11. So I just throw that out there for folks as thoughts and consideration about what time you'd like to meet back up tomorrow. Commissioner Najapa?
I support your 10 a.m. Suggestion, Mr. Chair.
Great. Are there other questions from commissioners or thoughts? AAG Davenport, do you have anything for us before we close today?
Thank you, Mr. Chair. The only thing this commission needs to do for the rest of today is adjourn to a specific time tomorrow. Though we'll have to have a couple of motions at some point tomorrow. The first one is a motion to continue this 800, 900, 1200 series rulemaking through, I think our practice has been just November 25th to be safe. The last time we continued this rulemaking, it was just to tomorrow. So we'll need a motion to continue that. We will also need to tomorrow briefly open the 2 through 600 rulemaking, just to adjourn that until Monday. We did say the last time we discussed the schedule that we would adjourn 2 through 600 to tomorrow. So just to be procedurally dot the I's and cross the T's, we'll need to do a couple of things tomorrow morning or at some point tomorrow. But right now, all you need to do is adjourn to a specific time tomorrow.
Okay, great. We'll look forward to your hand holding us to those things appropriately tomorrow. And unless I see folks with hands raised, I think we're looking for a motion to continue to tomorrow. What's tomorrow? November 20th at 10 a.m. Director Murphy, did you have anything? No, okay.
I will move to adjourn to tomorrow, 11:20 at 10 a.m.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? The motion carries and we are adjourned. Thank you, everybody, for participating with us yet again. We'll see you in the morning.